I am Dr. Jetling Yellosa, running a YouTube channel called titled Lost Speeches. In this channel, I am posting matters pertaining to the various facets of law as well as the world contemporary issues. And today, we discuss the intellectual property rights as the world is celebrating the World Intellectual Property Day today on 26th of April 2022. Every year world celebrates this day with much fanfare and enthusiasm. You know, we are celebrating this day on every 26th of April from 2000 onwards. As you know that the World Intellectual Property Organization is functioning from Geneva, which regulates and harmonizes the intellectual property matters around the world, and it had taken a decision in 1999 to organize a day as a mark of creating awareness and boost the innovations in the minds of the people. So that is the reason we celebrate this day, and for 2022 the theme of the celebration is intellectual properties and youth innovating better future. So for this year it has targeted the youth because the much of the knowledge is there in the minds of the youth. So it wanted to create awareness of the intellectual property rights in the minds of the youth. You know, human being is always instinct for the finding of the new things. That is the reason. As and today also, from days of primitive human being to the modern computerized smartphoneized human being, always the human being has thought for innovating the new things and innovating the new things. So intellectual property means a property which is created from our intellect, our mind. And these properties are not visible. These are invisible properties, but we have same sort of right, assertion, title over these properties. So what are those intellectual properties? The question arises in our mind. So intellectual properties have been classified as the properties which are innovated from our mind. Those include, one is patents, trademarks, copyrights, designs, trade secrets, know-how. So all these are part and parcel of the intellectual property regime. So these all are indispensable for our human existence. Without this we cannot exist. So patents, first of all we discuss. So patent is a scientific innovation which is useful for our existence is called as a patent. So in the international arena, We have number of regulations or conventions are there which pertains to patents. Those include, if you go back to 18th century, 1883, we have the Paris Industrial Property Convention, which is a general convention which is not only spoken about the patents, but also it has been spoken about the entire gamut of the intellectual property rights. And we can say that is the first convention after the Industrial Revolution has been come out in 16th century, which amalgamated all kinds of intellectual matters, and it was signed in Paris, France. And later, when the innovations have been started, which has been made, we have, as per the time and demand, we have enacted number of conventions specifically which are pertaining to intellectual matters. Those conventions are, the major convention is that the Patent Cooperation Treaty of 1970. So this convention harmonized the matters pertaining to the patents from all across the globe, because every country in the world had created one sort or the other sort of the patent enactments. So filing of patent from country to country takes lot of time, lot of money, lot of efforts. To remove this difficulty, WIPO came out with this convention called the Paris Convention. This Patent Cooperation Treaty Convention, and once you file one single patent, there it is applicable to the all the countries in the where the state parties are there to this convention. As on today, there are 120 states have been joined in this convention. Even our country also been part of this convention. And next important convention the patent law is concerned, that is the International Convention on Protection of New Varieties of Plants of 1961. You know, the agricultural revolution had resulted a sea change in our socio-economic conditions, and new innovations have come in the agriculture sector. New breeds, new seeds have been come out. So to regulate it, we have enacted this new varieties of plants convention in 1961, and later in the regional level also, the developed countries, like in the countries in the Europe, they enacted the regional convention that we called as a European Patent Convention in 1973. But as on today, there is no other regional convention we can find anywhere in the world except in the European countries. Then we have another important international convention with regard to patents are concerned, that is the Convention on the International Patent Classification of 1971. So patents have been classified. To deal with that matter, we have came out with this convention, And one more convention is the Convention on the Recognition of the Deposit of Microorganisms for the purpose of patent procedure of 1977. That is the Bucharest Convention, we can call it. So this convention also basically concentrates upon the microorganisms that is not visible to our eye. We require the other apparatus to identify that organisms, because the scientific innovation has resulted into creating of new things. Even we have added the micros organs. We created the number of, naturally there are innumerable microorganisms are there, but basing of our human requirement, we started creating the new organisms. So this some convention only applicable to the where human factor has resulted into the creation of the microorganisms, for not for the others. If it is natural organisms are there, this convention does not apply. Then we have the biological diversity convention. So these are the conventions which are with regard to the patents are concerned in international level. And in 19 the common convention also there, that is a GATT, General Agreement on Trade and Tariff. The talks were started in 1948 and concluded in 1994. In 1995, we come out with the World Trade Organization by Marrakesh Agreements. So there also the intellectual property matters, particularly the patent matters, have been inserted in that convention, Article 27 onwards. So those matters have become a trade-related aspects of intellectual property rights, and we can shortly call it as a TRIPS. Their product patent regime, process patent regime has been added in the TRIPS. There may be a lot of opposition came out from the developed countries, from the India, Brazil, Egypt, but the developed countries prevailed upon it, and they have succeeded in adding of the product patent regime into that aspects of the GATT, or to later it be called as a World Trade Organization. So this is with regard to, briefly with regard to the patents. And if we go for the trademarks, and I can say summarize that in trademarks also we have number of conventions are there in international level. Those include international registration of the trademarks of and there is one more convention called the Hague Agreement concerning the international registration of the industrial designs of 1925. That is with regard to the international designs are concerned. Then we have the Vienna Agreement on international classification of the figurative elements of marks of 1973. Then we have the Madrid Convention on the international registration of the trademarks. So these are some of the important international conventions with regard to the trademarks. And with regard to copyrights also we have some more international regimes conventions are there. Those include the Berne Convention, which is, we can say, is a basic convention where it is the literary works have been added in this convention. The convention is enacted in 1896, and we have the one more convention, the Universal Copyright Convention of 1952. where it covering the how what is the copyright, how it can be created, how it can be enforced. All those matters have been there. Then we have the another important convention. The copyright is concerned Rome Convention on protection of the performers and procedure rights, which convention is also very in one is signed in 1961, and a very important convention with regard to the trade copyrights are concerned. And WIPO, World Intellectual Property Rights Copyright Convention also will be there, and that is made, that has been resulted by the efforts of the WIPO. And with regard to designs also, industrial designs also, we have conventions are there, which is way back to the Paris Convention of 1883 also provided that. And in addition to that, we have the in 1925 we have the Hague Agreement concerning the international registration of the industrial designs of 1925. And like that, international regimes are there. In India also we have enacted before to before to independence and after independence, we have enacted number of enactments. Basically, in the intellectual property rights are concerned, we have the with regard to patents law, we have Indian Patent Act of 1970 is there, and with regard to trademarks also we have separate act is enacted, and copyright also we have enacted this copyright act. As per recently we refurbished our intellectual property regimes because the world needs a laws which are very akin to day-to-day issues. So basing upon that change and international efforts are concerned, international pressures are concerned, we time to time have been amending our enactments. With regard to patent law is concerned, we amended for 2 times in 2002 and 2005, and we added product patent regime. So we given up the Nehruvian influenced, a socialist influenced Patent Act of 1970. We made a drastic changes to 1970 Act. So intellectual property rights plays very important role in the development of any societies. You know, we can say a society in the path of development means how much the intellectual properties have been developed, that we have to see. To harmonize the intellectual property regime all across the globe, we created the World Intellectual Property Organization based at Geneva. And the World Intellectual Property Organization from time to time has been making efforts for harmonization of the intellectual property regimes all across the globe. Maybe we have some shortcomings are there. The law is nothing but it is a part of it is a natural phenomenon, is shortcoming is a natural phenomenon. But we have to strengthen for the betterment of the societies and ultimately to the human beings. So with this, I once again wish all of you a happy IP Day, Intellectual Property Day to all, and we have to take a pledge that youth should be involved, because the theme of this year's IP Day, which is framed by the WIPO, is intellectual properties and the youth innovating of a better future. So for better future, we have to innovate. That is the only option for our better future, and we have to involve the youth, because the 40% more than that also the youth is there in around the world. So thank you one and all for patiently watching my this brief video on today's World Intellectual Property Day. And lastly, I request all of you to, if you feel that my lecture is a good and informative, please like it and share among your communities. Thank you, one and all.